The market capitalization of the coin is used to summarize all that is taught in this video. I would also like to remind you to give my channel a like and subscribe to it so that you can stay up to date on future XRP news, as well as other cryptocurrency news in general. Take a look at this now, shall we? While the SEC appeals, will the price of XRP recover? On the other hand, before we go any further, there is a brand new cryptocurrency airdrop that is currently taking place on Telegram and is set to start at any moment. I would ask that you make sure that you take part in this airdrop. Within the video's description is where you will find the link. Make sure you don't miss out on this opportunity. In the meantime, let's proceed with our video. There are a substantial number of cryptocurrencies that have not yet recovered from the flash crash that took place on October 2nd in the cryptocurrency market. XRP's price fell by around 7%, hitting a value of $0.58 at the time of this writing. As a consequence of the Securities and Exchange Commission's appeal, which was filed on October 2nd, the price of XRP experienced a significant drop. This time around, the price has been reduced to $0.52 just, taking into consideration the data that was supplied by CoinMarketCap. The chief executive officer of Ripple, Brad Garlinghouse, is certain that the appeal will not change the current legal standing of XRP. This comes at a time when investors are expecting for October to be postponed. The most significant question is whether or not the price of XRP will be able to recover from the negative impact brought forth by the situation. On October 2nd, Bitwise, the leading Bitcoin index fund manager, submitted an application to establish an exchange-traded fund in the state of Delaware about the XRP ETF. Bitwise is the first company to submit an initial registration statement for a spot XRP exchange-traded fund to the Securities and Exchange Commission (SEC). This makes Bitwise the first company to do so. In spite of the recent excitement around exchange-traded funds, the price of XRP did not experience a significant increase. Despite the fact that this news broke at the same time as the appeal to the SEC, it did not have a significant impact on the price. The price of XRP continued its downward trajectory after experiencing a small improvement at $0.54 a price, reaching its lowest point of 51 cents. With regard to the forecasting of the price of XRP, the facts that were provided by Santiment indicate that XRP has emerged as the cryptocurrency asset that is trending the most in the wake of the event that occurred between December and October. Noteworthy is the fact that in reaction to a recent file with the SEC, over 250 million XRP coins were deleted from a number of cryptocurrency trading platforms by individuals who have chosen to remain anonymous. Worries have been raised as a consequence of this extensive shift, particularly in light of the increasing degrees of uncertainty that have been stated by XRP detractors. With the assertion that there is no prospect of a rally for XRP, a vocal Bitcoin maximalist by the name of Max Kaiser has made fun of individuals who buy XRP. In the same vein, Peter Brandt, an experienced trader, has announced that he believes the price of XRP will reach zero compared to the price of Bitcoin. The head and shoulders pattern, which has been established for 11 years, served as the foundation for his prediction. This message will be captured on screen by a large number of other people, and I will be reminded of it on occasion for a considerable amount of time in the future. The price of XRP is currently sitting at 53 cents, which is below the 200 exponential moving average. Additionally, it is getting closer to a significant support level, which is a level that is becoming increasingly important. If bearish pressure continues, there is a risk that the token will break below this level and fall to a territory that is somewhere between 48 cents and 49 cents. The fact that this is the case would suggest that the cryptocurrency is exposed to greater risks on the downside. On the Pacer docketing system, which is used by the United States Court of Appeals for the Second Circuit, a docket has been created for the appeal. According to the Securities and Exchange Commission, the organization that is being sued is Ripple Labs Inc., and the docket number for this particular case is 242648. Both the summary judgment that was released in July 2023, which included the verdict regarding the programmatic sales of XRP, and the final judgment that was issued on August 7, 2024, were put on the docket. Additionally, Ripple executives Brad Garlinghouse and Chris Larson were included on the docket. The opinions of Mark Fagel, who had previously worked as an attorney for the Securities and Exchange Commission, were voiced regarding the court filing. Regarding the identity of Ripple CEO Brad Garlinghouse and co-founder Chris Larson, Fagel made the following statement and provided the following information. There are a total of 2 allegations that have been lodged by the SEC against the individuals. They claim that these were unregistered securities transactions comparable to those conducted by Ripple when they initially sold them for their own personal XRP sales. In the beginning, they sold them for their own personal XRP sales. Due to the fact that these sales were carried out through intermediaries, the court came to the conclusion that they did not meet the criteria prescribed by the Howey Act to be considered securities. Further explanation was provided by Fagel, who stated that the court's decision to grant summary judgment in regard to Ripple's programmatic sales was made for the same reason. This is the ruling that the Securities and Exchange Commission (SEC) is appealing, and it is directly related to the sales of Ripple, as well as most likely the sales of the individuals. Start the litigation against the persons for assisting and abetting Ripple's registration violations by filing it with the Securities and Exchange Commission (CFILE). To put it simply, the CCCC filed a lawsuit against the individuals because they were the executives who gave Ripple permission to sell securities, including the institutional transactions that the court deemed to be securities. Fagel went into further detail on the fact that the court did not allow the defendant's motion to dismiss this claim, which indicated that the case was going to be tried in court. As a result of this, the Securities and Exchange Commission has made the decision to voluntarily dismiss the allegations of aiding and abetting, which indicates that such allegations are no longer alive and well. Regarding the initial accusation, which states that persons are engaging in direct sales, what are your thoughts? The individuals in question are still parties to the lawsuit, and it is likely that they are included in the appeal for the case. Ripple's chief executive officer, Brad Garlinghouse, has voiced his concern on the current legal proceedings led by the Securities and Exchange Commission's SE. He emphasized that the actions of the agency were detrimental to investors rather than having a protective effect on them. He said this in numerous occasions. Having clear legislative frameworks in place within the Bitcoin business is extremely important, as the continuing struggle has brought to light. It is necessary for investors and enterprises to have a set of guidelines in order to properly navigate this complex environment. Furthermore, the points of view expressed by Hogan are indicative of a growing sentiment within the community of cryptocurrency stakeholders. Many individuals are of the opinion that the aggressive measures employed by the SEC can be counterproductive. As a result of this, it is feasible that XRP and other digital assets will be able to challenge regulatory authority in a more effective manner. Because of this uncertainty, the trajectory needs to be altered. In the past, the Supreme Court of the United States has provided commentary on SEC's decisions. It was claimed in a post by Ripple Chief Legal Officer Stuart Alder that Bitwise would not have to be concerned about the SEC winning the appeal. This was said in reference to the previous statement. There is a high level of confidence within the leadership team of Ripple that the Securities and Exchange Commission may be unsuccessful in another case that is brought before the Court of Appeals. When he went to exit discuss a few of the responses that the regulator has received from the court in the past and its dispute with Aaron Govell, who is from Jacksonville, Florida, Doroti pointed to the appeal that was filed by the SEC. He went to exit discuss all of these things. When the matter was presented before the court, some of the responses that were handed out included phrases such as "we not agree with the SEC." These statements were among those that were handed out. Neither the SEC's counterarguments nor our own are convincing to us, and we are not convinced. An attorney by the name of Fred Rispoli is of the opinion that the XRPX traded funded will be subjected to a protracted period of waiting. This is due to the fact that Sesterpil, the largest holder of XRP currency, has been engaged in a 3-year battle with the Securities and Exchange Commissioning Sesterpil and has only just won partial success. The decision, which was handed down by District Judge Annalisa Torres of the United States of America, was considered as a big triumph for the whole cryptocurrency industry. On the other hand, XRP is not regarded as a security after it has been made available to individual investors on exchanges. However, when it is offered for sale to institutional investors, it is considered to be an unregistered transaction in the securities market. In a statement, Ripple claimed that they would not comment on the topic. However, they did reference the statements that CEO Brad Garlinghouse and Chief Legal Officer Stuart Alder made on X on Wednesday evening. The decision of the Securities and Exchange Commission (SEC) to appeal was reported by Alder as being regrettable, but not surprising, who made the statement that the company is currently contemplating whether or not to take part in a cross-appeal. During the time that Gary Gensler has served as chair of the Securities and Exchange Commission, the agency has earned a reputation for its inability to provide crypto companies with clear guidelines.